The President, please be seated. The court is now back in session. Next, we would like to hand over to the prosecution to put some questions to the expert. You may now proceed.
Thank you, Mr. President. Thank you, Your Honours. Good afternoon, Professor. The last session of the court day is arguably the most difficult time for all of us to concentrate, no matter what our age is. So I ask that you persevere with the questions that I'll ask. As we all know, a lot of ground has been covered this morning, initially by your summary of your opinion, and then by Judge Cartwright, and then by my learned friend, counsel for Ieng Sary. So I will go through some particular points that perhaps if you could cast some extra light on, and then we'll just move across a few of the different areas to focus just a bit of detail on some specific points, if you can. I will first ask you a few questions about his mental health, and then a few questions about his physical health, and then my colleague, Mr. Darasme Chan, will ask you some final questions as to the standard of care that you believe can be provided at the detention facility at the ECCC. So if I can start firstly with your experience in relation to assessing people with cognitive impairments, or alleged cognitive impairments, and people that may be faced with a situation that there may be an argument about whether they're fit to plead before a court or fit to make decisions as a result of certain legislative rights that people may have in any one country. And if I can point to your curriculum vitae, which is E62.1, if I can just quote part of that curriculum vitae as to what appears to be your experience in this area. And if I can quote, "For patients under his clinical care, he has filed many expert reports in the court concerning applications under the New Zealand Protection of Personal and Property Rights Act, legislation which enables a court to make orders for the personal care and welfare of those who lack the capacity to communicate decisions, as well as for the administration of personal property where a person lacks the capacity to manage his or own affairs. The majority of these reports concern patients with cognitive impairments, and in addition, you have provided reports to the High Court of New Zealand concerning the testamentary capacity of people whose wills have been challenged. And you've also provided an assessment for the court to enable it to determine if a person who had both physical and cognitive impairments was fit to stand trial. So in that context, can you provide the court with just a bit of further information about how many cases or how many reports over the years that you believe you may have written in each of these combined, but certainly on this particular issue of whether someone has the proper mental capacity to carry out their rights and obligations? Just briefly.
Mr. President, may I be heard?
The President, Dr. Campbell, could you please hold on? Counsel Kanawaz, you may proceed.
The question as posed is vague and irrelevant. It would appear from the doctor's CV, the part that was quoted, deal with somebody's ability to understand what's going on around them, whether they have the mental capacity to execute a will or whether they're mentally fit. That is not at issue. It is also a general question. Right now we're talking about, with respect to Mr. Ieng Sary, whether he is capable of assisting in his own defense and following the proceedings is able to concentrate. Now, if my learned colleague would like to narrow the scope of his question so that it reflects what we're really at in this, what is really at issue here, then I have no objection. But to simply say that the doctor has testified as to whether somebody is competent to execute a will, when that is not the issue here, is wholly inappropriate and unrelated and irrelevant. Thank you.
Your Honour, all I can say, I don't see how the question could be any more point in terms of this professor's expertise to be able to provide an opinion as to cognitive ability in relation to Ieng Sary. It couldn't be any more on point, Your Honour.
The President, the question put by the prosecutor is relevant. Therefore, the objection by the counsel for the accused person is not sustained. Professor Campbell, you are now directed to respond to the question.
Thank you. I assess people with cognitive impairment very frequently and often have to report to the courts if the person does not have an appointed person as power of attorney, and often have to comment on their capabilities when they're looking to appoint someone. Very hard to put a number on that, but it would certainly arise every month or two of my practice that I have to make a judgment in that area.
Thank you. Professor, I'd now like to turn to two of your reports. That's the 3rd of September report and the 6th of November report. And I'd particularly like to look at the tests that were conducted in relation to determining that Ieng Sary had the cognizant ability to be able to proceed in this trial. In terms of determining whether someone is fit to stand trial, is it the case that there's two areas that are looked at? One, at their cognitive ability, and two, at whether or not they understand the court process and can follow the court process and participate in it, as you've noted in the 3rd of September report in relation to the steps or the tests given by the case in Strugar. Are they the general two approaches that are taken to determine whether someone is fit to plead and stand trial?
Yes, that is correct. I have spent most of my time assessing Ieng Sary, looking at his cognitive function. That's both in the earlier reports and more recently. Sina Fazell and Lena Hewitt spent more time going over ensuring that he knew the court processes, his ability to plead, the consequences of the action. And as I've said, I found when I saw him this time that there was no reason for me to believe that there'd been any change in his ability to comprehend what the process was.
Thank you. And when we look at the 3rd of September report, as you've stated already, it was prepared by three professors. That was yourself, Professor Hoot, and Dr. Faisal. In terms of your involvement in determining his cognitive ability, were you involved in that in the 3rd of September, particularly in relation to the MMSE test that was done, or was your focus more on his physical health? Can you tell us how the work was divided up and perhaps how you collaborated?
In my earlier reports prior to the 3rd of September, I had assessed both his physical capability and his cognitive function. given that we had Sina Fazell and Lena Hewitt on the August assessment, I concentrated primarily on the physical, but we did discuss the report and the findings, their findings and my findings before completing that report.
And if your concentration was more on the physical, in diagnosing and working out a prognosis and treatment for Mr. Ieng Sary, did you have to have significant discussions with him to discover what his complaints were and other aspects to diagnose him properly?
Yes, that is correct. I mean, obviously, when one is assessing a person, even if it is primarily a physical assessment, one is very conscious of their ability to give a history, give an account of what's been happening, the consistency of their response. And if there is any cause for concern, one follows that up with more detailed questioning around memory and understanding. And in my dealings with Ieng Sary, I have not at any stage been concerned about his ability to comprehend, to remember his history, and to give me an adequate account.
Thank you. And perhaps if we can just turn to the mini mental state examination, can you briefly describe to the court what that entails and what it's designed to achieve?
It's a standardized test which is designed as a test of memory, and it covers areas of orientation both in time and place, short-term memory, ability to calculate, and spatial ability as well. And as I've said, he scored, when I repeated the test, above that level where one is concerned about cognitive function.
I believe in the 3rd of September assessment, he scored 28 out of 30. Is that correct? And when you conducted the test on the 6th of November, do you remember the score?
Because of the numbness with his fingers, he had difficulty with a pen, so had difficulty doing the pentagons in the sentence. But he dropped 2 points, so scored 26 out of 28.
And so he was able to pick up a pencil, at least attempt the test. He had enough movement to attempt that.
Yes, that is so. He just had difficulty constructing it and sufficient power on it to be able to use it. So, but in testing the sentence, writing a sentence, there was no concern at all about his speech, the fluency of it, his use of language. So didn't have any concerns in that area.
And just if you can clarify again, when you spoke to Mr. Ieng Sary on the 6th of November, just recently, did he complain of numbness in the hands and feet? And when he, well, firstly, perhaps if you can answer that question and I'll follow.
Yes, he did.
And so he complained about some numbness, and yet at the same time he could pick up a pencil and at least attempt. He could sort of move his arms and legs, but it was a feeling of numbness as opposed to the idea that my limbs are numb, I can't move. Is that correct?
That is so. I mean, the numbness is peripheral, distal, not proximal. He also has marked weakness now, and as I've said, I think that is primarily because of lack of physical activity over a number of years, coupled with his age.
And when we talk about peripheral numbness, are we talking about damaged nerve endings at the exterior of our body?
Yes, that is so, particularly in the areas he complained of light touch. But as I said, his position sense, that is, his sense as to whether I was moving his foot up or down, was preserved, and his reflexes distally were also preserved.
Is the term numbness and the idea of pins and needles, a tingling sensation perhaps, in the exterior parts of someone's body, is that the same? Are you viewing it in the same way, that basically that's the condition we're talking about, are pins and needles, or is it something different again?
Numbness is more an altered sensation, as if you're feeling it through cotton wool, for example, not as firmly. So that when I brought my cotton wool down his legs to his feet, he felt there was a change in sensation from just above the ankle.
So it's not a question of a loss of feeling, it's a diminished extent of someone's feeling.
You can lose sensation entirely, but his was a subjective loss.
In relation to determining Ieng Sary's cognitive ability, in addition to this diagnostic test, the MMSE, as part of that process to determine whether they have got good reasoning ability, cognizance ability, do you also, as part of that, discuss with the client, or in this case with Ieng Sary, to confirm that sort of reasoning ability, that awareness is there? So it's not simply just do the test, but there's another component.
Yes, that is so, determining if he knew what the process was, why we were seeing him, his ability, as I've said, to be able to give an account of himself and the symptoms and how accurate that is, and also involving in the discussion questions about family, just to get an idea as to how accurate he is and whether he's aware there. We discussed Ieng Turit and what had happened to her and how often he'd seen her. So just going back over issues like that to determine what his recall was, and there was no evidence of any impairment there.
And is it also the case that you're getting that reasoning ability as well when you're examining Ieng Sary or someone about their physical health, as much as their ability to remember short-term and long-term? So is it a combined assessment that you make from your two different lines of inquiry?
Yes, that's so. And also one is relying also on other people and whether they've noticed any change. And again, there was no indication from the doctors who'd been looking after him. And in our earlier discussions, there had been no indication that there'd been impairment of his memory or reasoning from those who were looking after him.
And in your discussions with Ieng Sary just recently, in relation to his cognizant ability, I think you've explained a little already what that discussion was and the types of things you talked about. Can you sort of wrap that up for us and tell us the topics, the content, and sort of the length of time you discussed those particular areas?
We discussed his current situation, his history, as I've said, and taking an accurate account as we could of his sense of dizziness, what that actually meant, when it occurred, and he's been quite consistent in his discussion there. In terms of talking around his family and his background, we did that at the end of the session to ensure that it was at a time when he'd been interacting, concentrating with us for some time, and there was no impairment there.
Thank you. Some questions were asked earlier about the qualifications, perhaps, of the doctor, Dr. Faisal, and Assistant Professor Hoot, as to their qualifications to be conducting assessments in relation to fitness to plead. And as you've said, back in August, they conducted an assessment and they asked him some specific questions that focused more, well, on the fitness to plead or the ability to participate in the trial aspect, aside from the purpose of determining the level of cognizance generally. I would like, perhaps, if we can move to that report, the 3rd of September, and I know you have, obviously from today, a very good memory, but perhaps if we could look at the 5th page, it's ERN 00846191 of that report, which is E11/86/1, and that seems to be just after the beginning of a recording of their assessment of Ieng Sary's ability to understand the trial process. And in that report, it appears that the two professors have used the Strugar test, which highlights the factors, the legal factors that courts seem to want psychiatrists or people doing these tests to consider to be able to help them understand whether or not an accused is fit to stand trial. If we move to page 6, could you just advise us again of the 7 criteria that the courts have asked and you applied in this report to determine whether he has fitness to stand trial? Those 7 criteria.
If I may briefly...
The President, Professor Campbell, could you please hold on, and Counsel Kanawaz, you may proceed.
Thank you, Mr. President. I would object to any specific questioning to the September report because that's not the purpose of the hearing here today. The gentleman, the professor, indicated that he knows what the standards are, so the prosecution can simply ask what criteria are in the Strugar test and whether he looked for those particular criteria. But to anchor the question based on a report that was written by others who are outside the expertise of this particular doctor, I would object to, especially since we are here for this particular report that this professor has conducted based on his most recent test. And since September, Mr. Ieng Sary has spent almost 2 months in hospital. Thank you.
Your Honour, counsel has just said that this professor doesn't have any expertise in this area of determining whether someone's fit to stand trial, and assuming also that he hasn't sort of got any expertise to deal with cognizance ability of old people. That is his expertise. As a geriatrician, that's his specialty. And we've heard just a moment ago him outline the amount of work and experience he's done in this process and in New Zealand in dealing with this very issue. So for counsel to say he doesn't have any expertise in this area is dumbfounding at the least. That said, counsel also stated that this report was not written by him. This report was written by him in collaboration with the other two. We've just heard testimony from the professor talking about how they worked together, how they divided work, and how they collaborated, and how their opinions on these issues reinforced each other. So it's wrong to say that he actually didn't write the report. He signed the report. And perhaps, I could ask the question, would you have signed the report if you didn't believe in its contents? The fact of an expert being able to refer to his own report is, that's obvious. And that's how we've been proceeding. And the fact that whether or not this professor was actually in the room when these questions were asked is not the issue. The issue is what information can he assist the chamber with. This issue was raised by Defence Counsel about the qualifications and the ability for the assessment to be correct of the 3rd of September. It's clearly a relevant issue. This test was done so closely to the test that was done only a few days ago. It's absolutely relevant, and I would ask that the professor be able to answer questions on this.
Mr. President, the prosecution has just mischaracterized my objection. First of all, we're here for his to take testimony from the doctor concerning his most recent examination. Second of all, I'm unaware of the doctor's specialty in forensic psychiatry. Now, if he is, he can tell us that, but that's what I was alluding to. No one has suggested that this professor, is not qualified in the profession in which he's told us he is. Nor have we called into question those doctors from September 3, but we have made it a point of saying that we have shown the report to our expert, who seems to indicate that there are reasons to believe that the tests that were performed were inadequate. So I have no problem with the gentleman speaking about what he observed on September 3. But we're here for what he did in his most recent evaluation. I think that's what is at thrust. These other two doctors have not come back. And he's not in a position to comment on what they would be saying here today because they weren't here. They haven't tested him. Now, he may have an opinion that were they to appear, they would testify the same way as they have in the past. That would be pure speculation, and I don't think the doctor is prepared to do so. But he can certainly talk about what his findings were and compare his findings to the findings from September 3. That I have no objection to.
The President, the Chamber would like now to hand over to Judge Silva Cartwright to address this issue. You may proceed.
Thank you, President. The Chamber has deliberated and decided that this is a relevant line of examination by the prosecutor and that it may, within the time limits available, continue. The Chamber also notes that there was no challenge to the 3rd of September report and therefore it is part of the context and the relevant material that the Court is considering today. Thank you.
Thank you, Mr. President. Perhaps if I can just remind you of the question. The criteria that you were required to look at, certainly as a group that prepared this report under the Strugar test to determine fitness to plead, could you make that clear to the Court, please?
Criteria were the ability to plead, to understand the nature of the charges, the course of the proceedings and the function of the people involved in the proceedings, the details of the evidence, to be able to instruct his counsel and to understand the consequences of the proceedings and, if required, to testify.
Thank you. And in determining, say perhaps if we go through each one in order, in determining whether he had the ability to plead, how was that done?
It's outlined in the 3rd of September report. That was done by Sina Fazell and Lena Hewitt. They've outlined their methods there. As I've indicated, I did not go through those again on this occasion because they had been done recently and there was no evidence either on history or examination that his cognitive function had changed, his ability to understand had changed at all since the report in August.
And we talked earlier about you being able to sort of determine a person's cognitive ability in the way they talk about their physical state, their physical health, perhaps as much as their mental health. And so certainly in that process, that examination on the 3rd of September, the health and the looking at Mr. Ieng Sary's mental health and physical health, were the answers that you were receiving from Mr. Ieng Sary and your view on his cognitive ability and being able to give those answers, were they consistent with the answers that seem to have given in relation to these 7 criteria on the fitness to plead in terms of cognizance ability and ability to reason and respond?
Yes, that was the conclusion of the 3 of us involved in his assessment at that time.
And if I can briefly ask you, in relation to his capacity to plead, in relation to that issue, what information did the 2 professors record to satisfy them and ultimately you of that criteria? If you can review the report, if you need.
They looked at his understanding of the nature of the crimes of which he was accused, the process by which he would be tried, the consequences if he was found guilty, and his ability to instruct his own counsel in terms of his own defence, and he indicated methods in which he would do that.
And if we look at paragraph 32, how did they record their view as to his their view that he appeared to have the capacity to plead? What information did they deem relevant in relation to that? Perhaps if you can read that information out so it becomes clearer. Yes.
Paragraph 32, Ieng Sary appeared to have the capacity to plead and stated that he believed that he was not guilty. He explained that, quote, "If I were the one who had knowledge and made decisions, it's a different story," close quote, but that he was, quote, "not involved with that," close quote. He explained that to be guilty, quote, "I have to know, I had to have been involved in decision-making," close quote, but he believed there was, quote, "no evidence," close quote, to prove his guilt.
And in relation to him appearing to have a basic understanding of the crimes which he had been charged, how did he respond to that?
Again, to quote from the report, he explained that he had been accused of, quote, "crimes against humanity," close quote, which he understood included, quote, "evacuation of people forced to move out of the country, acts of omission that allowed people to starve to death. As leaders, we are accused of forced labour and not providing treatment for patients, and crimes against Buddhism, the monks, the Catholics, the prohibition of religious practice, including demolition of monasteries and pagodas," close quote.
And in relation to the criteria of understanding the course of the proceedings as including an understanding of court procedures, the speeches of witnesses and lawyers to the judge, and the ability to communicate intelligibly on anything that is said by a witness and counsel, they've they've recorded his views on that. I'm just wondering if you can explain that to the court, if you can read that out, please.
Understand the role of the judge and explain that he would ask his lawyer to challenge anything that a witness said that he thought was not true. We felt that on the basis of this and related capacities that we tested, Ieng Sary did have the ability to understand the course of proceedings. And I gather that has been occurring. Ieng Sary has challenged or advised his counsel.
And if we move to paragraph 35, the professors state that they had taken the criteria of understanding the details of the evidence as including the ability to point out statements to which he disagrees and the ability to inform counsel of his version of events and any factors that should be brought forward in defence. And then they record their observations of Ieng Sary's to this issue. If you could read that out, please.
What they say is, on these factors, Ieng Sary appeared to have some capacity. He put forward consistent defences when we discussed the charges and appeared to have a good memory of the Khmer Rouge period and decisions made by the regime.
And if we move on, the professors have stated we've taken the related capacity of instructing counsel to include the ability to cooperate with counsel, informing counsel of the facts of the case, and assisting in the preparation of one's own defence. And can you relate their impression of his ability to do that, please?
Our impression was that Ieng Sary was able to cooperate with his lawyers, and he named his foreign counsel and explained that he had helped him and how he came to choose him from a recommendation from his Cambodian defence counsel. And I again, when I saw him earlier this week, asked him about his defence counsel, and he had no difficulty remembering. Yeah.
And if we move to the second to last one, it's recorded that Ieng Sary had the appear to have a good understanding of the consequences of any conviction. How was that finding found?
To quote from the report, he explained that he would be, quote, imprisoned for life, maybe 10 years or longer, close quote. If he was not convicted, he said that he would be free and would go and live with his family.
And dealing with the last criteria now, the professors have stated that our assessment suggested that Ieng Sary did have the ability to testify. Can you just provide the basis for that in relation to that topic? Thanks.
He seemed to have a good understanding of court procedures. He stated that he expected that all the judges would ask him questions, and then he would be posed more questions from the prosecutors, followed by the civil parties, and maybe the defence counsel of the co-accused, and he named the two co-accused. He explained that he would try to answer all these questions.
And in that 3rd of September report, and it's been discussed already in court, however, it was your opinion, along with the two other professors, that Ieng Sary did not suffer from any mental illness or cognitive impairment beyond what would be expected for someone of his age and background, and therefore have no recommendations to make in relation to mental state or cognitive function. That was your opinion on the 3rd of September, is that correct?
That is correct, and there has been nothing in my assessment of him on this occasion that would make me change that opinion.
Thank you. Perhaps now if I move to perhaps two last questions on this topic generally and the ability to concentrate. You were asked questions by my learned friend in relation to is it possible that Ieng Sary could doze off in the afternoon and not be able to follow the proceedings? And your answer to that scenario was that Ieng Sary would have the capability, the ability to concentrate and follow the proceedings for a whole day, bearing in mind the breaks and the lunches, etc. Can you just explain that a little bit more in the idea that you said that people could doze off, but he's got the capability. What I want perhaps to get some clarity on is, are you saying that he has the capability to do it for a day with the breaks, that if he wanted to, he could concentrate at a certain level for that whole day? Is that what you're saying?
Yes, that is what I'm saying. I mean, he is obviously more physically frail now, but in the right circumstances that would not be an issue. The court sitting sessions are not long, and there are certainly adequate breaks in between. As I've said before, I mean, often people doze off in circumstances. That doesn't mean they haven't the ability to concentrate. It just means that if things aren't very exciting for a time, we have that tendency to nod off.
So ultimately, for you, it's more of a question of willingness to concentrate and participate, as opposed to the ability to concentrate or participate.
Yes, that is so. And I mean, when there are particular issues which he feels strongly about, I'm sure he'll maintain his concentration. There may be other times during the court hearings when it doesn't seem particularly relevant to him, and at that time his concentration may lapse. But that is something that would happen to any of us.
Correct. One question in relation to specialities and expertise. We talked about you having a slightly different opinion about VBI, vertebral basilia insufficiency syndrome, or ischemic. You also said you having a different opinion to the doctor that testified, but you also said it's not out of the realms of possibility that could develop or that could occur at some future time. So just in terms of that possibility, why would how would you say that? Why would that be a possibility?
What I'm saying is that none of his current symptoms can be attributed to vertebral insufficiency, and he has no physical signs on examination to indicate that he's had small strokes, for example, because of insufficient blood supply from that system. What I am saying, though, is that he's 87, he's got a history of high blood pressure, and he also has a history of coronary artery disease, which indicates that his coronary arteries are narrowed. Now, it is highly likely that he has some narrowing of the arteries supplying blood to the head. Currently, they're not causing any symptoms, but anyone of 87 with coronary artery disease who has high blood pressure is at risk of a stroke in any of the territories, vertebral territory or the anterior circulation. So even were he to have a stroke tomorrow, again, it would not mean that his current symptoms are due to vertebral ischemia.
And is it not also the case that people of an advanced age that may be physically fit for that age, many of them end their lives with a stroke?
That is correct. He is at greater risk, of course, because of his high blood pressure and because of his heart disease. But currently on examination, there is no evidence that he has had a stroke.
And I'm looking now at a report of the 19th of September, E11 87/2, 00848 142, and the doctor's report of a paradoxal septum with a conserved ejection fraction of 58%. Can you just explain briefly what an ejection fraction is and the figure of 58%, whether that's reasonable for someone of his age even without heart disease.
The ejection fraction is the proportion of blood in the left ventricle, that's the main pumping chamber that pumps the blood out to the body, the proportion of that that's present when the ventricle is finished filling, the proportion of that that's pumped out to the body. And a 58% is actually a reasonable preservation, given that he has had heart attacks before and he has got areas of his heart muscle that are not contracting fully.
So with that ejection rate being reasonable, also with the arteries to the back of the brain not showing much constriction or thinning, would it be fair to say that although there is he has a history of heart problems, at the moment his heart condition is stable?
His heart condition is stable, but it is precarious. So it hasn't deteriorated over the time that I've been seeing him. He does have heart failure. That's an inability to pump adequately and for pressure to build up behind the heart. But currently that is adequately controlled with his medications.
And just in, I think I went off topic, but in relation to some of the other doctors that were seeing Mr. Ieng Sary, isn't it the case that you're not in debate with many of the diagnosis that has been stated, but particularly just in relation to the VBI? Is that correct?
That is correct, yes. I mean, there was some issue about impairment of the blood supply returning from the brain, obstructed by the clavicle or collarbone. I'm not sure whether it was a problem in the transcription, but that's not a plausible explanation. That simply doesn't happen.
And just in relation to your expertise as a geriatrician, would it be fair to say that your expertise deals with all major critical functioning aspects of the body, because you need to be able to see the interdependency and the interrelatedness of one condition on another? Because when you get older, we generate a number of different conditions, as opposed to when we're younger and we may have one issue, and on that basis perhaps we would go to one particular expert. But is it the case that your expertise is different perhaps than the others because you're more familiar with the interdependency of the conditions and the cause and effect relationship between them?
Yes, that is correct in two aspects. Firstly, when we're dealing with people of 87 in the older age group, they have a number of comorbidities. So it's not just conditions affecting the heart, it's also likely to be arthritis, lung problems, a number of different problems. The second thing is that when one looks at a particular symptom, in a younger person that's most commonly can be ascribed to a single etiological causative factor. But in older people, there are often a number of contributing factors to a particular symptom.
And from the doctors that you met that have been examining Mr. Ieng Sary at the hospital here, are any of them, as far as you know, qualified geriatricians in terms of that being their specialty?
No, not as far as I'm aware. I'm not sure there are geriatricians in Cambodia given the age structure of the population.
Thank you. Mr. President, just to give you a plan, I believe I would have another five minutes of questioning. My colleague, I think, has about 10 or 11 questions relating to the treatment at the detention facility. We've spoken to the civil parties and they've advised us that they may use the 15 minutes or they may use a little bit less. Bearing in mind the time, I would ask that we continue till, say, 10 to 4, and then perhaps if submissions are required, we would ask that perhaps on another day that we could come and organise our thoughts. If that's acceptable to the President, can I proceed on that basis? Basically, we finish in 20 minutes.
The President, indeed, you may proceed, but then please make sure that you are straight to the point so that we can finish on time. Counsel for Mr. Nuntia, you're on your feet. What is that you wish to address the chamber, because you are here as an observer rather than the... And we don't know what kind of point you wish to make.
Thank you, Mr. President. Good afternoon, everyone, and good afternoon, Professor Campbell. First of all, if I may just respond to what you've just said. You said this morning that the other defense teams would be given the floor at the end of the day. That's what I heard you say. That's what everyone on this side of the room heard you say. And just before the lunch break, you said that all of the parties would be given an opportunity at the end. That's what I heard.
The President, perhaps that was a misunderstanding, because on Tuesday we also told parties to the proceeding that we only allow the counsel for Mr. Ieng Sary to participate in the proceeding, and that we allow other parties to observe the proceedings if they would wish to do so. However, we are afraid that other parties other than counsels for Mr. Ieng Sary would not be allowed to make any observation or be heard during the proceeding. You may be seated.
Thank you, Mr. President. If I could just clarify what I...
The President, you please be seated.
I would only have one general question for Professor Campbell. It would have nothing to do...
The President, you are not allowed to be heard because you are here as an observer rather than the parties to the proceeding. And as an observer, you are not entitled to be heard. We hope it is clear. Please be seated, and please make sure that you make the most of your time as an observer rather than the party to the proceeding. And the chamber would like now to proceed to the co-prosecutor to continue putting questions to the expert instead.
My time?
The President, no, you're not allowed. Please do not interrupt the proceedings because we're running out of time.
Thank you, Mr. President. We'll take heed of your words and be as quick as possible. Professor, I just have two questions, then my colleague has 15 minutes. We'll just ask you about whether the standard of care at the detention facility is significant, sufficient to give Mr. Ieng Sary the best medical option. My last questions are, if we look at the three main complaints that you assessed Mr. Ieng Sary as having, is shortness of breath, the lower back and cervical pain, dizziness and unsteadiness. Would you agree that one of the most perhaps immediate health concerns that Ieng Sary has is that he might fall over because the muscles are not as strong as they should be or could be, and the most immediate thing that might happen to him is if he falls over, and then if he falls over he could break a bone and have other complications, and that would be extremely detrimental to his health. Is that reasonable to say given the current situation?
Yes, that is a very real risk. Fortunately, he is very aware of that and so does ask for assistance when he does need to move.
And my last question is, if that's the case, would you agree with me that aside from him taking the appropriate medication, aside from him having the appropriate personal care, this exercise program you talked about, within the limits that he can do it, is fairly essential in terms of his ongoing health? And if he doesn't start a program like that to the level that he can with a walker or something similar, then his condition would likely worsen.
Yes, that is so. He is very weak now. He has a condition we call sarcopenia, which is loss of muscle bulk. It makes him very frail, makes him very susceptible to falls and fracture, but also means that his body reserve to counter any intercurrent illness, such as an infection, is very much compromised. So he is at risk. And if he is able to participate in a program, that may build that up a wee bit, but it would require his cooperation.
And that's my last question. Do you get any sense from him, from your discussions with him, whether he's willing to participate in extending himself a little to exercise to give him more strength?
My impression is that that's unlikely. He does, for example, when moving, complain a lot of his back pain, and that may mean that he's reluctant to actually participate in a program. But if he could undertake one, it may be helpful.
Would you say that with the appropriate physiotherapy and coaching and guidance by someone, that would be quite important to give him the confidence and the know-how how to actually begin?
Yes, because it has to be at a level within his capacity, both cardiac and in terms of his muscle function. It is unfortunate that he's not had any program during the time that he's been in hospital.
Thank you. Now, thank you, Professor. I just hand over to my colleague who has some questions for you. Thank you.
Mr. Chandarara Samai. Good afternoon, Mr. President. Good afternoon, Your Honours, and very good afternoon to you, Professor John Campbell. I am Chandarara Samai, National Co-Prosecutor, and I will have a few questions concerning your recommendation you already stated in your report to the court on the 6th of November 2012. In your report, you document E238/4 ERN 0858949 in Khmer. English ERN is 00858700. On point number 19, you indicated that Mr. Ieng Sary that he be discharged from hospital. He is not receiving any medical treatment that could not be provided outside hospital. So your recommendation is that he be discharged from the hospital and returned to the detention facility. Could you please tell the chamber how the medical or how the care is carried out at the detention facility to improve his condition at the court?
Well, I think his condition is stable at present. As I've indicated in the report, there have been no changes to his drugs, medications over the last 2 to 3 weeks. So it's not as though his medical condition is being closely monitored with a view to changing therapy. The main issue at present is his physical dependency, and that is being managed by assistance to help him with his standing, and there is no reason for a person to be in hospital for that to occur.
Question. Thank you. Is there a need to change the current system concerning the care of Mr. Ieng Sary, because he has already been properly cared at the detention facility? Should there be a change to the same regime of care?
He has the doctors at the detention centre who monitor his progress. If there were any deterioration, they would be able to call on additional expertise if they needed that. The main change in his condition and requirements is in his increased physical dependency. So his medical condition can be adequately monitored in the way that it was previously.
Question. Can you also please tell the chamber what else needed on top of what the medical service provided by the treating doctors who are on standby at the detention facility? So my question is that what should be more services offered by the doctors to him?
I don't think there's any need for additional medical support. I raised with the doctors at the hospital why they felt he still needed to be in hospital, and the answer I got was to deal with any emergencies. There have not been any recent emergencies. If they were, they could be dealt with at the detention centre. If necessary, he could be transferred back to hospital. But there is no need to maintain him in hospital in anticipation of such emergencies. And I'm not sure what emergencies they were actually referring to.
Question. Thank you, Professor. Having noted the beds for Mr. Ieng Sary, do you feel that the bed is comfortable enough for a person like Ieng Sary, or should you wish to recommend that there should be some changes to the bed condition for him, for his better health?
In hospital, he's on a bed similar to that in the holding cell, and he's perfectly comfortable on that. If he needs to sit slightly propped up to watch the monitor, then that could be assessed to see how comfortable he is in a bed in which the head of the bed can be elevated. If he finds that comfortable, if it doesn't disturb his lower back, then that might well be a useful alternative to have in the holding cell.
Question. Do you believe that the food ration offered by the kitchen at the detention facility is adequate for Mr. Ieng Sary?
Yes, he does have additional food brought in by his family, which he enjoys, and that could certainly continue. There are dietary supplements that can be used, and they could be tried to see if he did find them palatable and worth trying.
Question. Thank you. Can you please advise the chamber as to what kind of equipments be recommended for Mr. Ieng Sary to use in the detention facility to improve his physical condition, for example, for allowing him to do exercises?
I think that would depend very much on the program that the physiotherapist established for him. I don't think it need to be sophisticated at all. The main issue is in the strength in his legs, and simple ankle cuff weights are usually adequate for building up proximal leg strength, which is the critical area to work upon. I mean, it's very important that he continue the exercises when the physiotherapist's not there. So again, we don't want particularly sophisticated program. It needs to be a simple program that he can carry out on a daily basis.
Co-prosecutor, thank you very much. Can you please tell the chamber whether you envisage that there would be some trainings for the medical staff at the detention facility to make sure that heart condition of Mr. Ieng Sary improve?
I think there's very little scope for improvement in his heart condition. They have been monitoring it adequately. If they need additional advice, there is the cardiologist that they can call upon for that.
Thank you. Based on the current health status of Mr. Ieng Sary, are you satisfied, according to your examination, that the current medical service received by Mr. Ieng Sary at the detention facility is the same as that provided by doctors at Khmer Soviet Friendship Hospital?
I mean, it's a different level of service. He does not have daily access to the specialist cardiologist or neurologist, but with his condition stable at present, I don't feel that's necessary anyway.
Co-prosecutor, I thank you very much. I have the final question to pose to you. And this final question is relevant to your recommendation. Do you believe that the current service provision at the detention facility is adequate for him to remain at the detention facility rather than being admitted to the hospital?
I feel in his current condition, which is stable, the medical services available at the detention centre are adequate. I feel he will need additional personal support if he is in the detention centre, similar to that which he's receiving in hospital. But that's at a level of nursing or personal care.
Okay.
Co-prosecutor, thank you very much, Professor Campbell, for your responses to my colleague and to me. I wish you safe travels and all the best. Thank you, Mr. President, and your honors for the floor. The President, next, the Chamber would like to hand over to the lead co-lawyers for the civil parties to put some questions to the expert.
Mr. President, on behalf of the lead co-lawyers, I'm going to give the floor to my colleague Vanichet and Pascal Auboin for the questions.
Counsel Chet Van Lee. Good afternoon, Mr. President. Good afternoon, Your Honors. I am Chet Van Lee, representing the civil parties. I have no question to put to the expert, but I would like to cede the floor to my colleague for putting questions.
Bonjour, Monsieur le Président, Mesdames.
Good afternoon, Mr. President, distinguished bench, and all parties here present. Good afternoon, Professor Campbell. I am Pascal Auboin, civil party lawyer. We have heard a number of statements in this chamber, the defence, the prosecution, and yourself. The civil parties feel fully confident about the report that you have written, and on behalf of the civil parties, I will simply take this opportunity to thank you for your contribution to this process. Thank you.
The President, thank you very much. We have little time left. However, we would like, as indicated, we would like to give opportunity to parties to make some observation, but the time is too little for that already. The Chamber wishes to inform the parties to the proceedings that the follow-up hearing on this will be conducted on the morning of Monday, the 12th of November, after after this session, the Chamber wishes to hear the testimonies of some witnesses as well. And we already coordinated with the Office of Administration to coordinate with the Khmer Soviet Friendship Hospital to have Mr. Ieng Sary return to the detention facility and the court. And today it is his right, and based on the report by the expert, he can enjoy observing the proceedings, and momentarily the chamber will send him to the detention facility. By Monday, the chamber will continue hearing testimonies of some witnesses and civil parties, and at the same time we would like the security personnel to bring Mr. Ieng Sary to observe the proceedings from his holding cell. We may take this opportunity to also seek advice from the expert who is before us today, whether it is appropriate for Mr. Ieng Sary to be returned to the holding cell to observe the proceedings. Indeed, the decision on his participation in the proceeding is pending, because we have just heard your opinions and report, and that only until we won't have any hearing until Monday. So for this time being, we would like to know from you what you would say about this.
Thank you. As I said in my report, I don't see any medical reason why he should not return to the detention centre, providing that the additional personal support that is needed can be provided, so that he gets adequate assistance, for example, when he is moving from bed to chair, so that he does not have a fall and a fracture.
The President, the Chamber would like to hand over to Judge Silva Cartwright to inform the parties and the public concerning Ieng Sary condition and how we handle him, or whether he should be present or not during the court proceedings when we hear testimonies of some civil parties in the following week. Mr. Ieng Sary has expressly said that he would like to waive his right to participate in the proceedings concerning the certain witnesses and civil parties. Somehow, we would like now to hand over to Judge Silva Cartwright.
Thank you, President. The trial chamber notes that it is appropriate to make an interim determination concerning where Ieng Sary will reside, pending the delivery of any decision on Ieng Sary's current health status. The Chamber has noted Professor Campbell's opinion that Ieng Sary does not currently require hospitalisation. The trial chamber therefore decides that Ieng Sary is to return to the detention centre, where he is to continue receiving full medical treatment as before and as discussed during today's hearing. The trial chamber also directs the detention centre to provide additional personal assistance to ensure Ieng Sary's physical safety and to enable him to attend to his more personal requirements, such as toileting. The trial chamber therefore orders that the accused Ieng Sary be returned to the detention facility. It notes that the accused has waived his right to be present for the testimony of those witnesses who have been summoned to testify for the remainder of November 2012. Therefore, the Chamber does not require his presence in the holding cells during those hearings. Any decision that the Chamber determines concerning Ieng Sary's health status will follow in due course, and an order requiring his attendance in the holding cells will also be given. The trial chamber intends to give the parties an opportunity to make oral submissions on Monday, the 12th of November, before we begin the hearing of witnesses. We have not yet determined how long for each of the parties, so perhaps, President, we could briefly confer on that to give the parties an indication of the duration of such oral submissions.
The President mic is not activated. The President, thank you very much, Professor John Campbell. The hearing on your testimony as an expert has now come to an end. You are now excused. Your report and testimony will be used as the basis for our consideration and deliberation on the health status of Mr. Ieng Sary to see whether he is fit to be present in the proceedings or not. Now the chamber wishes you all the best. We wish you the very safe trip home. Court officer is now instructed to ensure that Professor Campbell is returned home safe and sound. The hearing of today comes to an end. The chamber will adjourn. The next hearing will be convened on Monday, the 12th of November at 9 a.m. On Monday, the chamber will be hearing the remarks, observations by parties to the proceeding concerning the report and opinion by Professor Campbell. Counsel for Mr. Ieng Sary will have 20 minutes for that, and co-prosecutors and civil co-prosecutors will have 15 minutes, when the lead co-lawyers for the civil party will have 5 minutes. And the final 5 minutes will be offered to counsel for Ieng Sary to finally reply to this. And on Monday, the chamber will also be hearing witness TCW 507 after the floor is given to the parties concerned with regard to the remarks already stated. Counsel Kanavas, you may now proceed.
Just one moment. We didn't have an opportunity to thank Dr. Campbell for coming here. We wish to thank him for giving his testimony. It was rather spirited, but nonetheless, we do thank him, and we wish him a safe journey back home. Thank you very much for coming here.
Thank you very much, and thanks very much for the courtesy of the chamber. I might add as an aside that I wore today the cufflinks that my daughter gave me, my computer cufflinks, which have CTRL on one cuff, control, and ESC escape on the other. So if things get too tough, I can press both and whoosh, I'm gone. But as you can see, I'm still here, so I haven't needed it. Thank you very much.
The President, security personnel are now instructed to bring Mr. Ieng Sary back to the detention center. The court is adjourned.